We're still focusing on what's been happening in the political space as Nigerians look forward to next year's general election. Some of the intra-party developments have come to pose questions of legality or otherwise regarding processes and approaches towards the nomination of candidates ahead of the elections. We will now get to interrogate some of these processes with a view to finding out the position of the law by speaking with Dr. Babatunde Ajibade, a lawyer and senior advocate of Nigeria. We'll also take him up on ongoing efforts by the Nigerian Bar Association to push through reform of the judicial provisions in the 1999 Constitution through the convocation of a Justice Sector Summit. You're welcome, Dr. Ajibade.
Thank you very much.
Good morning.
Good morning.
Good to have you.
Good morning.
All right, we'll come to the MBA issue, but I would like you to enlighten us because we've basically entered, the political season. 2022 will be essentially all about politics, and the two big parties are in the news, especially the ruling party, which incidentally, hopefully, will be having its convention on the 26th of February. But then, in the eye of the law, how will you assess what has been happening with a sitting governor, Governor Buni of Yobe, presiding over the affairs of the party for more than 1 year, almost a year and a half now, after it was meant just to lead a caretaker committee for a couple of months. Now, Supreme Court, the feeling of the Supreme Court is being interpreted by different people, given what happened after the Ondo State election. What do you think has happened in the eye of the Lord? And do you think, whatever the outcome of the February 26th, would that have successfully put right what looks patently wrong?
Thank you very much. I did indicate even before this interview commenced that these political issues are things that I personally feel that the legal profession, apart from lawyers who are engaged to represent one side or the other, but the legal profession as a whole should make a conscious effort to steer clear of, to remain as neutral, yes, and just neutral as possible. These are matters that may or may not end up before the courts for determination. Yeah. So any view I express here, I'm here in a representative capacity representing the NBA as chairman of its Judiciary Committee. So any view I express here would definitely be to the prejudice of the NBA as taking one side or the other. So for that reason, I really would rather not delve into political issues.
Okay.
All right.
We'll grant you that breathing space.
We will.
Let's take a few steps back. Just now we were speaking to Professor Patutomi, and even though we spoke about many things, the crux of our conversation was to talk about the power of the diaspora and the fact that as it stands now, it's impossible for Nigerians in the diaspora to be able to cast their vote when it comes to election season. That is obviously a legal issue as it stands now, despite the appetite among many Nigerians, not just here, again in the diaspora. It does seem as though they continue to hit constitutional roadblocks. What are your thoughts on how that can be broken past and making sure that Nigerians outside of Nigeria with legal stay in other countries have the right to be adequately represented in their politics?
I mean, as an aspiration, I think that is absolutely legitimate. And as we're in a season where the Constitution is supposed to be undergoing another review, it's probably a perfect time to address whatever stumbling blocks are in the way. Once the technology is there, and I heard Professor Otomi saying that even smaller countries, less endowed than Nigeria, have created the opportunity for their citizens in diaspora to vote. So I really don't see any reason why we shouldn't address that frontally in the course of the ongoing constitutional review process.
That's right. But tell us now the proposals from the NBA towards, reviewing the 1999 Constitution. I know that the NBA itself is also reviewing its own constitution, proposing to do so as we speak. Yes. So it's dealing with, two issues, internal and then the issues of the Nigerian constitution. What are the key areas of amendments that the NBA is putting forward?
Right. The NBA has sent a bill to both houses of the National Assembly. The committee is dealing with the constitution review process. And we've made far-reaching suggestions to address some of the fundamental stumbling blocks that we see in achieving what we all want, which is a strong, efficient, and vibrant justice sector. Some of them are mundane. Some of them are addressing issues such as there was a query when COVID hit as to whether virtual hearings are constitutional because of the provision of Section 36 that says fair hearing proceedings must be held in public. And there's still a question mark as to whether a virtual hearing is public. Even though the Supreme Court has made pronouncements on it, but the pronouncement was made specifically saying this issue is not formally ripe for determination, but we don't think there's anything wrong with it. So we've seized the opportunity to suggest that that issue should be clarified in the Constitution so that there's no doubt. We don't want a situation like the Ojiuzo Kalu matter where there's a provision in the law, but then it goes all the way to the Supreme Court only for the Supreme Court to now say that it's. So we've tried to clarify that, but that is one of the simpler ones. Some of the more fundamental issues.
But if I may, what was NBA's suggestion regarding that?
So NBA's suggestion is that there should be a specific provision in there that says that virtual hearings
is public.
Yes, it's a public hearing and that it's constitutional, just to remove the controversy. But some of the more fundamental, in my view, is what we're trying to do with the issues as to administration and funding of the courts. As you're aware, last year, one of the greatest challenges the justice sector faced was the Judicial strike.
That's right.
Focused on the questions of financial autonomy for the judiciary. And our view is that the provisions of the Constitution at present are not fit for purpose. We have provisions that, in one breath, say that the judiciary should be funded from the Federation account, and in another breath say the judiciary should be funded from the Consolidated Revenue Fund. So internal inconsistencies even in the constitutional provisions. Then secondly, we have provisions that seem to indicate that the judiciary, both federal and state, should be funded by the federal government, whereas between 1999 and now, the federal government has actually only been responsible for funding the recurrent expenditure of the judiciary at state level, but the state governments have been the ones funding the capital expenditure. Now, Jusun went on strike without addressing these fundamental inconsistencies in the Constitution itself. So we're saying that we need to address this. We need to agree, do we want a unified justice sector where all the judiciaries are beholden to the federal government, or do we want a proper federal structure where you have state judiciaries for which the states are responsible, and federal judiciary like the Federal High Court, the National Industrial Court, the Supreme Court, the Court of Appeal, for which the federal government is responsible. There has to be clarity. Yes.
Does the NBA have a preference in those two options?
Yes.
What is the better choice for you?
Our preference is that we call ourselves a federation. So really, we should be federation not just in name, but also in practice. So our view is that the state governments should take responsibility for funding the state judiciaries, whilst the federal government takes responsibility for funding the federal judiciary. But this has implications. It has significant implications for the allocation of funds as between the state and the federal. Because if currently the federal is taking that burden, if we're recommending that that burden should go to the states, then of course there has to be a rejigging of the allocation of funds between those two tiers of government. So, and as I said, because these are fundamental issues, this is constitution review season, there's no better time than now to resolve these issues with finality rather than leaving it to Jusun and strikes, because those strikes will not resolve those inconsistencies in the constitutional provisions.
You think all this will end once there's a constitutional finality on them?
Definitely, of course. I mean, the constitutional finality has to be headed in the right direction. And just as I said, for me, it's not necessarily what solution we arrive at. I mean, we have our views as to what the best solutions will be, but there must be clarity. You can't have a constitution that contains inconsistent provisions. I mean, for example, the issue I raised about whether the funding is from the Federation account or from the Consolidated Revenue Fund. The Supreme Court has already, in a decision, I think in 2011 or thereabouts, has already held that Section 162(9) of the Constitution really is ineffective because it's saying something contrary to another section. So we shouldn't have a constitution that has this kind of contradictions, internal contradictions, especially where we're dealing with something as important as the justice sector.
The issue of the, sorry,
no,
Femi,
please go ahead.
The issue of the additional law schools, I mean, does it also feature in your proposal?
No, because it's not a constitutional, it's not a constitutional issue, but I can assure you, well, this is not something that we've debated, but I can assure you that speaking for myself, additional law schools should not be the priority right now. Our priority should be reinforcing and strengthening what we already have rather than creating more weak institutions.
We have 6 now? Or?
Kano, Abuja, Yenagoa, Lagos, I think Enugu, yes.
Yeah.
Yes.
Okay, that's fine.
If we can shift focus to the Justice Sector Summit, tell us what that seeks to do and what we can expect from that.
Okay, so the Justice Sector Summit, the NBA and I think the entire profession is concerned about the state of affairs in the justice sector. Things are just not working the way we would like to see them work. And this decline has occurred over time. And what we're trying to achieve with this summit is we want to stop talking about the problems because we do a lot of complaining, whether you talk to a judge, you talk to a lawyer, you talk to an average citizen who has the misfortune of having to use our courts. Everybody's complaining. And we know that we can't solve all the problems at once. So we've identified what we consider to be the 3 most critical challenges facing the sector at the moment. And these challenges are all connected. We think one of the most fundamental and one of the most important is the process by which judges are appointed. Because if you don't have the right quality of persons going into the justice sector, you can't get a right result. You know, in computing language, you say garbage in, garbage out. So we need to ensure that it is the right quality of people that are going into the judiciary. The appointment process leaves a lot to be desired. There are too many loopholes in the process, and it has been overly politicized. I think it's clear to everybody that the ideal should be a process that emphasizes quality and merit rather than political connection. But over the years, that has become the norm. And it's not to say that we don't have any good judicial officers, but they seem to be the ones that slip through the political net. So we're going to address that frontally. That is one of the first issues. The second, which we've touched on already, is the administration, funding, and budgeting for the judiciary. The judiciary as an arm of government is severely underfunded. It is underfunded, it is undermanned, and we cannot get what we want out of that justice sector. If you have just over 1,000 judges of the superior courts in a country with a population of over 200 million. And you can't get more judges if you don't put more funds into that sector. And over time, the judiciary, because of its position, in our view, does not have the capacity to agitate appropriately for an increased allocation of funding. I mean, the judiciary has to be seen as neutral. Now, if there are cases between the citizen and government, and the judiciary is seen as being at loggerheads with government because it's not been adequately funded, then it would create the impression that, oh, you're already biased even before cases come before you. And that is where the bar has, in my view, not done enough, because it's one profession. Judges were lawyers before they crossed over to the bench. So even if they can't speak, the bar definitely can speak. And I don't think we have spoken loudly enough to ensure that this other arm of our profession, this is our shop. So if the shop is not being properly catered for, we're not going to get the best service out of it, and society is going to suffer as a result. Right. So we want to deal with the issue of funding, budgeting, and administration of the courts as a fundamental issue. And then the third is delay, which is also a knock-on from the first two. If the quality of the judges is not right, then they can't deal with matters as efficiently as you would like them to. If they're not sufficiently funded, then you probably can't get the right quality of personnel in there because it's not attractive. Why would you want to become a judge if the perception is that, judges are, they're not, it's not, they all go to the same market, they send their children to the same schools. If you're not confident that you can get in there and earn a reasonable living, then why would you want to become a judge? So appointments, funding and budgeting, and then deal with the consequent challenges with delay. Although the delay problem is probably the most intractable because there are other issues that cause delay. Okay. The inefficiencies in the sector that go beyond just appointment and funding. The inadequacies of the support that even judges get. Because a judge needs, you need a good administrative structure around you. You need to have a registry that's functional, that's efficient. You need to have registrars, court clerks, bailiffs to serve processes. So all this we need to address. And then structural issues, lawyers as well. We are also part of the problem. Because the mindset of a lot of lawyers we require a significant amount of reorientation. If we realize that the purpose of going into the justice delivery system is to deliver a result. That result, you also need to play a part in ensuring that result is delivered efficiently and quickly. But too many lawyers would go to court and obfuscate to the frustration of the judges many a time, and to the confusion of their clients. So we need to change our orientation, change our mindset, make better use of case management procedures that are out there that will enable the court system to work better. So these are the issues that we want to address.
Understood. The second thing you mentioned was funding, and obviously it makes a lot of sense. You have to make sure the judiciary accurately or efficiently funded so that they can go around business as usual. But there's a huge problem with corruption when it comes to the judiciary. The fact that people can pay for judgments that will be along their favor. So, while we can say that there's making sure that judges are paid more offers a holistic solution to that problem, corruption seems to be enshrined within the Why am I struggling with this word today? Within the judiciary. So when we talk about corruption and those issues, how can you separate the two? Can they be separated? It just seems as though anybody, as long as your pockets are deep enough, it seems as though even within the judiciary, everybody has a price, and that's a problem.
No, that is definitely a problem, and I think the perception is unfortunate. It's the most unfortunate perception that you can buy justice. And I'd be the last person to say that there isn't corruption in our judiciary, but I think it is, the perception of it is worse than the reality. But relating it to what you've said, personally, I don't think that anybody who takes on the position of a judicial officer has any excuse. There can never be any excuse for succumbing to corruption. But taking it to funding, I think that it is also a recipe for disaster to put people in a position where they are susceptible to temptation, and you don't do your part to ensure that they will be able to resist that temptation. So, I don't think any judicial officer has any excuse. There's no excuse for being corrupt. But I think also the structure has to ensure that they are assisted to resist the temptation to be corrupt by ensuring that they're well taken care of. And I'll tell you one of the most significant aspects of it. For me, it's not even so much what they're doing when they're in office. It is the fact that the system does not cater for them anywhere near adequately when they're out of office. And that is a major problem. Because, if you are in office, you're provided with a house, you're provided with an orderly, provided with an official car. Oh, great, whilst you're in office. And then once you're out of office, suddenly it becomes your problem.
Understood.
Then there is, of course, a natural tendency, except you already have your own means. And this is another issue. One of the things we're going to do at the Justice Sector Summit is to administer polls. And when you look at the UK, for example, where we derived our legal system from, you find out that it is the best of the bar, QCs, SANs, the equivalent of SANs that go to the bench. Now, typically, if you've been an SAN or a QC for a reasonable period, you're already relatively comfortable. So you wouldn't be taking judicial office in order to make money. You'd be taking judicial office in order to solidify, to serve, to solidify your reputation, contribute to the development of the law, contribute to the development of society. So here, is that a factor? Do we factor that in to say that if you want to take judicial office, there must be evidence that you actually have some financial means? Because if you don't, then the temptation, more susceptible to temptation. So these are fundamental issues. Like I said, they're all connected. So if you look at the appointments process, do we actually do that? Do we establish that the judicial officers we're appointing are people who will not be taking office because they see it as a means to make money through corruption? But people who are going there because, they want to contribute to the law and to the improvement of society.
All right, Dr. Ajibade, I would have loved to ask you about how all these align with the CJN's proposal, to the Constitutional Review Committee, particularly on Section 230, that were recommended a reduction in the number of, Supreme Court justices from 21 to 16. But we really don't have time. However, you were able to speak as your good self on the citing or creating more law schools. But then you declined to speak about the legality or otherwise of the Buni-led APC, chairmanship, caretaker committee. Why are you not able to, you are a son. We would just love to know your understanding of what this means in the eye of the law.
No, as I said, and I think I made myself clear, and you're trying very hard to get me to shift my position. That is a partisan issue. Yes, and I don't think it is appropriate for us to take a position on a partisan issue because the NBA must be seen to be non-partisan. So there's no way I'm going to comment on that where it's not going to be either I'm saying, APC is in trouble or APC is not in trouble. It's not for me. I don't think it's our place to comment on that. But you've raised an issue that I would like to comment on. Our recommendation in relation to constitutional reform goes the exact direct opposite of that of my Lord the CJN.
Wow.
Yes, we recommend that there should be an increase in the number of Supreme Court justices, albeit a cap, just to say, and then leave it to the Supreme Court to determine exactly how many to appoint.
That's right.
And this is actually a fundamental area also of addressing the concerns. The Supreme Court's jurisdiction currently is too broad. The Supreme Court of Nigeria is probably the busiest Supreme Court in the world. A Supreme Court should be a policy court. It shouldn't be a court that's dealing with rent matters, right. He owes me, he didn't pay, etc. So
understood.
That's
all righty. Well, thank you very much.
Thank you, and I hope that the NBA is now fully united after Olumide Akpata emerged and the what are they called? Egbe Amufin Agba or something. That you are now properly assuaged. But that's all we can take.
All righty.
That's a discussion for another day.
Okay. Okay. Well, we look forward to it. That was Dr. Babatunde Ajibade, Senior Advocate of Nigeria. Thank you for joining us.